We have our first phone caller on the line, Kate from Bay County. She has a question about an estate question. Kate, you can go ahead with your question now.
Thank you very much, Courtney. Yes, I have a question. It's, say you have a family member that has a durable power of attorney that she's appointed for herself, and the durable power of attorney set up a life estate for her property and her home. But the durable power of attorney prepared the paperwork, is the beneficiary of the residence and of the property. She's the beneficiary of it. She prepared it. She also signed it as the POA and misspelled the person whose property it is and whose she's representing, their name in the signature. Is that a legal binding document? If not, what can the other family members do about it?
Kate, it's a great question because a lot of times people give what we call POAs, power of attorneys, and we draft those for clients sometimes that have to have a family member or a good friend step in their place or to help them out. You have to be very, very careful. When you execute a power of attorney, you're actually giving that person the authority to act on your behalf as if that was you acting on your own behalf. So without looking at the fine details of the power of attorney, and sometimes there's limitations as to what the POA actually allows for someone to do, but assuming that it's a open-end power of attorney, that person's able to legally act on behalf of the person who gave that power of attorney, and assuming there's no maliciousness or wrongdoing behind it, it very well could be a valid document, a valid transfer. Doug, you want to add to that?
Yeah, Chris, I would just say this, for Kate, that I wasn't 100% clear on the facts, but it sounds like what she's saying is there's an allegation of potential self-dealing, and just because you have a durable power of attorney, in other words, you're the donee, you're the recipient of it, you owe a fiduciary duty to the donor, the person who's given you the power of attorney, to act in their best interest, not your own. So if I understood the facts correctly, I think Kate probably should speak to a civil attorney in town just to check into it, because I think what she's alleging is self-dealing, and that would violate the fiduciary duty reposed in the recipient of the power of attorney.
But Doug, absent self-dealing or fraudulent transfer issue, people have to be very careful when they execute a power of attorney and give that person the same rights as the donor has.
Yeah, you certainly don't give it to someone you don't trust.
Yeah.
You give it to a trusted person, but if I was understanding right, the issue here would be if the donee, the person holding the power of attorney, is signing a deed giving the person a life estate in the property, and then the remainder to the person signing it, that
would,
red
flags there.
Yeah, red flag. That's all I'm saying, and without knowing all the facts, but it does raise questions in my mind.
Right.